Good morning, Chris. I'd just like to say before I start that I have used some different cases in the plea and not the ones that I put in the scenario. Good morning, Your Honour. If it may please the court, I would like to submit a plea in mitigation of Mr. Waite's penalty. I ask Your Honour to consider a non-custodial sentence consisting of community service orders without recording a conviction. This is within the sentencing range for the offence. In regards to the facts, Your Honour, Mr. Waite did not deliberately strike Mr. Barrett with a beer glass, but rather he deliberately struck while holding it. The strike was consistent with an unpremeditated reaction. These facts were not disputed by the prosecution at trial. Mr. Waite was acting under the influence of alcohol and encouraged in his actions by his friend, who cajoled him to fight when he said, "Give it to him, Richard." Mr. Waite was instantly regretful and remorseful and apologised to the victim straight away. He then asked the bartender to call an ambulance. Mr. Barrett is left with a small scar but no noticeable disfigurement. Your Honour, I would like to advance some matters in mitigation of penalty. Mr. Waite is a young 24-year-old man whose actions were the result of poor judgment on the night in question. He has no prior criminal conviction and he has never been to jail. He was remorseful and apologised to the victim. He pleaded guilty from the very beginning. When filled with alcohol and encouraged by his mate, Mr. Waite let good sense go out the door. He feels ashamed about what he did and feels this was out of character. He finds the incident himself hard to understand. He thinks he may have committed the act in a moment of bravado to impress his friend, but he realised how bad his actions were straight after the incident. Mr. Waite is not normally a man of violence. He has never had a fight in his entire life. Your Honour, Mr. Waite is employed as a service engineer for a heavy plant and manufacturing company, Caterpillar. He has been employed with them since leaving school in Year 12. Mr. Waite is engaged to be married and the wedding date is set for next month. Mr. Waite fears that a custodial sentence will mean calling off the wedding, even though his fiancée is standing by him through all of this. Mr. Waite has a number of good character references from family and friends that have known him for a very long time. One is from a doctor, one is from a solicitor, and the other is from the manager of Meals on Wheels, where he volunteers in his spare time. All of the references are aware of what happened on the night in question. The references all state that they are surprised by Mr. Waite's character on the night in question. They normally describe him as a very even-tempered young man. The references all state that they believe the offence occurred as a result of poor judgment on the night in question, and they believe that this will be a one-off occurrence. In regards to sentencing options, the maximum penalty for unlawful wounding is 7 years imprisonment under S 323 of the Criminal Code, Queensland. The options Your Honour has for sentencing under the Penalties and Sentencing Act include probation orders, community service, intensive correction orders, suspended imprisonment, probation orders and imprisonment. We suggest Your Honour, in light of the facts and the good character of Mr. Waite, that a community service order in the vicinity of 200 to 240 hours, including not recording a conviction, would be an appropriate penalty. The sentencing guidelines that are applicable under the Penalties and Sentencing Act include S13, which state that a court in imposing a sentence must have regard to the guilty plea in take that into consideration and may reduce the sentence had the offender not pleaded guilty. A reduction may be had also having regard to the time of the guilty plea and when the law enforcement agencies were informed. Your Honour, Mr. Waite pleaded guilty from the beginning, and a reduction in sentence should be given to Mr. Waite under this guideline. Under S12, Your Honour, a court may exercise its discretion whether or not to record a conviction, and the court may have regard to the character and the age of the defendant and the impact a conviction would have on the defendant's social economic well-being and their chances of finding employment in the future. As has already been submitted, Your Honour, the defendant is still very young and an imprisonment sentence would have a detrimental impact on the social and future well-being of Mr. Waite, given his usual good character. His wedding with his fiancée will also have to be called off, and this will have a big impact on his social well-being. He will also lose his job. Under S9 of the sentencing guidelines, the court must have regard to the risk of any harm to any members of the community if a custodial sentence were not imposed, and the need to protect the community. It is submitted, Your Honour, today that this is a one-off occurrence due to poor judgment by Mr. Waite. His good character references have attested to this. In regards to the offence and the circumstances of it, the court must have regard to this in sentencing. We ask for leniency because he was encouraged by his mate while filled with alcohol. The blow was not premeditated, but rather a reaction to his friends condoling. Further, under S9, the court may have regard to the actual injury of the victim, the past record of the offender, and the offender's age and character. As has already been submitted, Your Honour, Mr. Waite is still young and is of usual good character. He has no criminal history and he's very remorseful for his actions. Mr. Barrett is also left with a small scar on his chin, but no noticeable disfigurement, fortunately. It is conceded, Your Honour, that the prevalence of this offence is a concern of the court, which it must have regard to under the guidelines. Other cases of this type involving a beer glass and unlawful wounding vary between facts, with some of the defendants intentionally using the beer glass as a weapon and others have been spontaneous reactions. The courts generally see a penalty of general deterrence as a fitting punishment to stop the prevalence of the offence. The issues that help the court to decide between comparable cases include whether the blow or strike was premeditated or not, whether the defendant deliberately struck with the beer glass or whether they were just holding it when they did, whether the beer glass was used as a weapon, and whether the defendant has any criminal history, and the consequences of the crime on the victim, the injury to the victim, and the amount of scarring and pain caused. A common penalty for the sentence is 12 to 18 months imprisonment fully suspended. To assist Your Honour, I have prepared a book of authorities. The book includes the leading cases on the issues to assist Your Honour in deciding the sentence. I will now give you an overview of the cases. In Police versus Walken in 2011, the injury was more serious to the victim and the defendant received 18 months imprisonment with release on parole, with immediate release on parole. In R versus Bennett in 2007, the defendant had a criminal history of common assault and sexual assault. He was sentenced to 18 months imprisonment with parole after 4 months. This case can be distinguished on the basis that Mr. Waite does not have a criminal history or violent background. In R versus Glenn Edward Kevin Hayes, ex parte Attorney General, the case had similar facts and the blow was spontaneous rather than premeditated. The order from the court was 18 months imprisonment wholly suspended. The court stated that the sentence imposed was due to considerable mitigating factors such as the defendant's age, character, and the early guilty plea and the remorse of the defendant. However, Your Honour, it is submitted today that the case of R versus Munro in 2012 in the Queensland Court of Appeal has the most comparable facts of all of the cases. The defendant in this case did not deliberately strike the victim with a beer glass, but he struck while holding it. The defendant was also of the same age and had a very good character. No prior criminal history. The defendant was usually of good character, like Mr. Waite, and their actions were spontaneous rather than premeditated. Neither used the beer glass as a weapon, as in other cases. The injury to the victim was slight scarring. This case involved an appeal against sentence being manifestly excessive. The defendant was originally sentenced to 4 months imprisonment, fully suspended, with an operational period of 18 months. However, the court in this case did not vary the sentence imposed because they did not find that the sentence was manifestly excessive. However, the President and other members of the court agreed that comparable cases indicated that a non-custodial sentence may also have been within the sentencing range. Your Honour, today we ask the court to impose a non-custodial sentence without recording a conviction. Based on the President's and other members of the court's remarks in Munro, Mr. Waite showed remorse instantly, and it's highly likely he is not a risk to the community. Your Honour, we ask for leniency and submit that this offence will be a one-off occurrence, given Mr. Waite's usual good character. His character references have attested to this. Your Honour, that concludes my plea on behalf of Richard Waite.